Good morning, Mr. Ncube.
Good morning, Chief Justice.
How are you, sir?
I'm very well, thank you.
Thank you. Colleagues, good morning. I want to begin by welcoming Judge President Japi in our midst. Honorable JP, good morning. And also—
Good morning, Chief Justice. Yeah.
Thank you, my brother. And also Acting Judge President Mia. Good morning, my sister.
Good morning, Chief Justice.
I also welcome on behalf of the Premier, Honorable MEC Mshengu. Welcome and good morning, MEC.
Good morning, CJ.
Thank you. Mr. Ncube, you hold a B.Juris degree, LLB, diploma in environmental law, but you didn't end there. You've gone all the way to a Master of Laws degree in environmental law. Am I right?
That is correct, Chief Justice.
Did you focus only on environmental law or did you do other courses as well?
I focused on environmental law, yes.
So it was a thesis from the beginning.
Yes, yes.
And you've been a magistrate for how many years now?
I've been a magistrate for 38 years now.
First as district court magistrate and then regional court magistrate since 2014 until now.
Yes, that is correct.
And you've acted several times in the land claims court. Is that correct?
Yes, that is correct.
All in all, for how long would you say you've acted as a judge of the land claims court?
I started acting there in 2006, but I would come and go 2006, 2006, 2008, 2009. Then in 2016, I acted continuously up until now.
Yes. So you're quite comfortable in that space?
Yes, I believe so.
Thank you very much. Before I give the opportunity to the JPs and the MEC to put questions to the candidate, may I have the list of colleagues who have questions for Mr. Ncube, please?
Lamola.
Judge Meave.
Singh.
Honor.
Dodogu.
Schlemmer.
Ofu.
Chief Justice Judge Japi.
No, you come in automatically. You and AJP Mayor and the MEC come without, you have a right to come in. I'll start with you, JP. After Honorable Dodovich, Prof, and who else?
Bofu. Did you get my name,
yes.
CJ Sretaba?
Yes, sir. You come just before Commissioner Barnard.
Is Muimang on the list, CJ?
Thank you, sir.
And JP
And
Mlambo.
Ma, yes, CJ.
Thank you. Thank you. JP, let me start with you.
Thank you, Chief Justice. Mr. Ncube, I've seen you've had several stints acting in the KwaZulu-Natal High Court. You understand that the position that you are now applying for would leave you somewhat with a foot in both courts, that is, in the High Court in KwaZulu-Natal and in the Land Claims Court. You understand that?
Yes, I do.
Yeah. You started, well, when I found you there in 2017 as Judge President, and you were then acting as a High Court judge. And from time to time, you were seconded to the Land Claims Court.
Yes, that is correct.
Can you just tell us, how did you find that arrangement, Mr. Ncube?
It is the arrangement which I'm comfortable with. I was able to work under those conditions, working in both the High Court and also the Land Claims Court. I did not find it difficult. I did not encounter any problem whatsoever.
What concerns me is did it interfere with the time it took for you to complete both matters and judgments in matters that you was sitting in? Do you understand the questions? I mean, moving from one court to the other sometimes would cause a delay in the court that you are not sitting in. Do you have anything to say about that?
There were no delays. There are no delays which occurred in the handing down of the judgments, and because I usually work even after hours, I work on my judgments, and during recess, I work on my judgments. So there's no time where I can say that my judgments are delayed because of this working arrangement.
Well, speaking for myself, I have seen you there during recess,
Yes.
working on it. The sort of work that you did in the Durban High Court, from my understanding, it was both civil and criminal work that you did.
Yes, it was both civil and criminal work. Yes.
And your experience, could you cope with the work that was being given to you, both in the High Court and in the Land Claims Court, in the sense you didn't feel overburdened by it all?
Yes, I could cope, and I coped very well.
Yes. And you've been doing this since 2017, as far as I know.
That is correct.
Yes.
JP.
Thank you, Chief Justice.
Thank you very much, JP. Acting Judge President Mia.
Good morning, Mr. Ncube.
Good morning, Acting JP.
Mr. Ncube, you started off your career in 1982 as a court interpreter, and today you are interviewing for appointment to the bench. I think you need to be commended for the great strides you have made in your career.
Thank you.
Mr. Ncube, you have been one of the mainstays of the Land Claims Court, certainly since the time that I have been the head of the court. And the court has operated under somewhat difficult circumstances because we don't have permanent judges appointed yet. But you have operated under those difficult circumstances based predominantly in KwaZulu-Natal with great efficiency, for which the court is grateful. You've also traveled all over the country, like many Land Claims Court judges do. It's a lonely job. Help me understand what excites you about the work you do and makes you want to carry on this kind of nomadic judicial existence, if I can call it that, rather than the comfort of being a regional court magistrate.
I think what excites me is the passion I have for human rights and also for land reform legislation, land reform law. That is the passion which even drove me into making an order, which I made the order for the appointment of a special master of labor tenants. I went out of my way, although it was an order which had never been made in this country, but I went out of my way and made an order for the appointment of the special master of labor tenants because of the problem which was facing the labor tenants. They had applied for the acquisition of land through the department, and the department took long to process their applications. And it came to the stage when they approached the land the Land Claims Court, and they asked the Land Claims Court at least to appoint a special master who was going to work hand in hand with the department and try to speed up the process of processing the applications for the acquisition of land. Well, I made that order knowing that it could be said that I stepped the judicial mark, and in fact, the SCA found that that order amounted to judicial overreach, and the order was set aside. Fortunately, the Constitutional Court did not agree with the SCA, and the Constitutional Court reinstated my order. In fact, the Constitutional Court found that it was not judicial overreach, but it was the effective judicial intervention in an endeavor to assist the poor, the landless, and the least advantaged members of the society who had waited for 20 years to get what the Constitution was promising them, to get land which the Constitution was promising them, but they were held back by the department, which was not processing their application. So it is that passion which is driving me to work, to go all out and work all over the country and work closely with the Land Claims Court. And it is a court which is close to my heart because of its of inquisitorial jurisdiction. We sit down with the people sometimes, in a pre-trial conference and try to help them to resolve their problems, because litigation is expensive, and it would be better sometimes if you settle the dispute without going to court. So that is the passion which has kept me going all this time.
Thank you.
And also I can add that as I'm in case that I'm working with the community which I like, and the community which I know, the community of labor tenants and farm dwellers. Those are the people whose culture I understand. I understand their cultural practices, and I speak their language.
Honorable MEC.
Thank you so much, CJ. Good morning, Mr. Ncube. Well, the Constitution of the Republic enjoins us to, amongst other things, heal the divisions of the past. And one issue that keeps on dividing the people is the issue of land. Now, you wrote a judgment in the Mwelase case, which gave some glimpse of hope that the slow pace with which land issues are being resolved is going to change. But since then, really, nothing much has changed in terms of resolving these issues expeditiously. And there are other frustrations, such as the high costs that are associated with land restitution. But also in KZN would know that most of the land there belongs to Ngonyama Trust, which by implication means that individual households and families can't really have some kind of security of tenure around the issues of land. Now, what do you think should be the role of courts in removing the remaining impediments in order to fast track the issue of land restitution, but also in intervening in the plight of those who are landless and poor, therefore can't afford the expenses related to taking the issues to court, but also around the issues of Ngonyama Trust? I would be interested in getting your views around the issue of Ngonyama Trust versus individual households who can have a security of tenure. Thanks.
For now, I would say that I don't see the Ngonyama Trust as being the big issue because at the present moment, the labor tenants are staying in the private lands. There are no labor tenants who are staying in the Ngonyama Trust land. They are staying, or they reside in the land which is owned by private farmers. And I think as from now on, with this new land court bill, which I believe would be below Parliament, in front of Parliament soon, I think the land court will be capacitated because it is going to have permanent judges who are actually going to see to it that the work is done and that it is done quicker than it was done before when there were no permanent judges. With the question of access to justice in respect of people who are poor and do not have money to hire attorneys and advocates, when we have legal aid, and at the Department of Rural Development and Land Reform, they also have a unit. They have attorneys, a unit of attorneys who are prepared to help the people if they want to take their cases to court. And also, it is the duty of us as judges of the Land Claims Court, if the person comes there unrepresented and he wants representation, legal representation, we write a letter to the department and ask the department to appoint an attorney or an advocate for those people who cannot afford legal fees.
Okay, thanks, CJ.
Thank you, MEC. Honorable Minister.
Thank you, CJ, Sanbonani, Mr. Ncube.
Yeah, Minister.
Yes, mine is this matter that you have resolved on, the Moelasa one, where you created a special master. It was indeed a novel intervention, but it has really created problems for us because now between ourselves and rural development, you are aware that we have got what is called the master's office at justice, and the special master, according to the ruling, somehow still coordinate with the Department of Rural Development. But that gray area where the master has a role to play in supervising also the work of this special master, because it's called special master. So it's a difficult conundrum that we find ourselves in, although we've tried to find some kind of a workable solution to assist this process. But what will be your advice in terms of the interaction, in terms of government cooperative governance for the special master between ourselves, rural development, and also the role that it's supposed to play for the land claims court?
I think, Minister, we must understand that the special master is not there to take over the work which is to be done by the department, but he is there in order to assist the department in doing its work. In actual fact, the special master is the agent of the court. It is the court which is working through the special master. As Judge Cameron found in that Moelase judgment, he said that in actual fact, the appointment of the special master is nothing else but the extension of the independence of the court. So it is the court which is working through him. And I don't think that there will be any problem. There should not be any problems, actually, if we understand that in actual fact, he is working for the court and he is not working for himself. If he encounters a problem, he goes back to the court with the problem which he has encountered, and we sit down with him And we also sit down with the people from the department and we iron out the problems which are there.
Yeah, in practice, it has become clear that he or the special master can only work also with the support of the department. So that line is a very thin one between being an agent of the court or an agent of the department, and who accounts to parliament. All those gray and difficult areas is what we are grappling with in this matter.
Now, the minister and the minister of land affairs or rural development is accountable to parliament, and the special master has got nothing to do with parliament actually, but he has got everything to do with the court.
Yeah, I don't want us to belabor the point. I just want to get clarity because it will help us as we engage on the matter. Because as you are aware, the budget, the staff, and all that has to come from the department to assist the special master. So that blurs that line between the court and the department. So I want to get from you that, in your view, this indeed is a novel intervention which the department is supporting, and we work very well with the special master, including from our side where there's some confusion whether this special master relates to the master of the High Court that we have.
Yes.
There's been some clarity. We've had meetings, lots of meetings to just get that clarity. But that line is always there, particularly when it comes to budget allocation and all that, to give support to the work of the special master. Whether it should come from the court budget or it should be from the department, and where must it be housed and how and what. So those kind of things have been some kind of a difficult solution that we've tried to find, but I think we're on a day-to-day basis trying to help that the special master.
Yeah, I understand.
Yes.
I understand, but it should not be the problem. The way I look at it, it should not be the problem. So far as the budget is concerned, it should not be the problem, because whether the special master is there or whether the special master is not there, the department is still expected to process these applications. That budget which the department was going to use in processing the applications is the budget which the department is going to use now in collaboration with the special master. I believe there was a budget which was set aside for the processing of the applications of the labor tenants. So if that budget is there, the department must use the same budget, but in conjunction with the special master to process those applications.
No, that's fine, Mr. Mngube. With your indulgence, CJ.
Go ahead.
Yeah, Mr. Mngube, this is a different one.
Yes.
What is your view with regards to the expropriation without compensation? Do you think now, in terms of section 25(3), can you be able to expropriate land without compensation or at nil compensation below market value, as the Msiza case has found, which was overturned by the Supreme Court of Appeal?
Yes.
And if you think so, do you think that if there is any ambiguity, the process in Parliament that is currently unfolding, is it, must we, as we have agreed that we are going to proceed to clarify, will that be helpful for the work of the Land Claims Court?
Yes, I think we cannot talk about access to land without talking about expropriation of land without compensation. I think it is the only way out for South Africa. I don't think there is any other option. Well, sometimes people think that Section 25 of the Constitution they think that Section 25 of the Constitution is all about land, but it is not all about land. It is about property. Even the heading of Section 25 is property. So it is a clause which is dealing with property, not land per se. So if it is going to deal with land, the Constitution must expressly say so. The Constitution must expressly provide for expropriation without compensation. As it is now, it is vague. It is not clear whether there can be expropriation of land without compensation. But if we want to expropriate land, it must be clearly provided for in the Constitution. More so because Section 25, subsection 4B says that property is not only limited to land. So it is properties that clause. Section 25 is a clause which is talking about land, which is talking about property, but not per se talking about land per se. I know that people have always said that Section 25, subsection 8 can be used by the government in order to expropriate land, but I do not agree, because Section 25, subsection 8 will take us back to Section 36, which is the limitation clause. Now, if it takes us back to Section 36, which is the limitation clause, we are going back to square one. We are going back to Section 25. Why? Because Section 36 says if you want to limit the right, that right must be limited in terms of the law of general application, and the limitation must be reasonable in an open and democratic society based on human rights, equality, and freedom. So in other words, what this clause is telling us, it is telling us that we cannot expropriate without compensation, because Section 25 says if you want to expropriate, you must expropriate, but must pay compensation. There are only 3 requirements if you want to expropriate land in terms of Section 25. Land can only be expropriated in terms of the law of general application, and it must be expropriated for a public purpose or public interest, and it must be expropriated subject to payment of just and equitable compensation. So under Section 25, there is no way you can expropriate without Section 25 being amended to make it expressly that you can expropriate land without compensation. I know that the bill, the expropriation bill, Section 12, subsection 3 of the expropriation bill says that it can be just and equitable to expropriate, it can be just, and then it says it can be just and equitable for land to say something about nil compensation, to expropriate with nil compensation payment. It is not clearly drafted. It can be just and equitable to expropriate with nil compensation payment. But now I can assure you that if that clause remains like that, and if Section 25 is not amended, that clause will be declared unconstitutional because it is in conflict with Section 25 of the Constitution, which does not allow expropriation without compensation.
Okay, so in your view, that Section 25 3 may not lead to a calculation that will be nil compensation?
No, it may not.
Okay.
Unless Section 25 is amended to express provision for expropriation of land without compensation.
Okay, no, thank you, Mr. Ncube, and thank you, CJ.
Thank you, Minister. Honorable Singh.
Thank you very much, Chief Justice, and good morning to you and to all the commissioners and the JPs and everybody else that's in our admin team. Kambola, good morning to you.
Good morning, sir.
Good. Thank you for your responses to the minister, because I was going to follow up on that. But one of the issues I know, as a judge sitting on the Land Claims Court, your primary responsibility is to adjudicate over disputes that may arise, not only with labor tenants, but also between property that's owned by somebody and communities or other individuals may claim that property. Now, from your experience sitting in that court for as many years as you have, I would like you to share with us the administration side of bringing these matters before court. As you're aware, the cutoff date for lodging applications was 31st December 1998. And I remember at one stage, there were over 14,000 unprocessed applications just for prima facie evidence that there are claims, and that is by the department or the Land Claims Commission. What is your experience with regards to administration? You know, in a case, you get prosecutors bringing cases before you, they have to be well prepared. Can you just share your experience? Because is that not also holding up the expeditious resolution of land claim matters?
Oh, clearly, that is one of the problems. That is one of the problems which we experience in the land claims court, because we come at the adjudication stage. We have no way of getting hold of the matter before the matter is brought to us. So we rely on the commission and the department to bring cases to the court. Before the cases are brought to us, there is no way we can control them, unless there is a person who is strong enough to come and apply for a mandamus and ask us to issue an order that the department must bring, or the commission must bring a certain case to court to be dealt with by the court. But up until that stage, there's no way we can deal with the matter until it is brought to us.
No, I agree with that. But what's your experience with regard to the administration? Do you think there are serious challenges there that are holding up matters that need to come to court if they have to?
There are challenges, but I do not know whether the department is guilty of not bringing the matters to court on time. Maybe the process takes long. Process itself takes long because they start by investigating the matters to see if the matter is ripe to be taken to court. If there are delays in the investigation itself, of course, it will take long for the matter to come to court. But I don't want to put the blame squarely on the department and say it is the department which is delaying. Maybe they are delayed by the fact that sometimes they must go out to the rural areas and they must look for the claimants, and the claimants are not there. The claimants are far away, and they have to travel all the way looking for the claimants and interviewing the claimants. There are so many sorts of problems involved.
No, thank you for that. And just as an aside, perhaps on interpretation of 25(3), there is a commissioner sitting there who shall remain unnamed, but he's a senior counsel who gave us a different opinion. But anyway, let's see when he asks questions. My second question relates to, we get a lot of people writing about you know, communal land and title deeds. Do you think there is still a place, and for how long is there a place for the existence of communal land in South Africa in general and in KwaZulu-Natal in particular? Thank you.
By communal land, I understand the land which is owned by the community or by the chief.
Indeed. Well, not well. As far as I'm aware, the Amakosi just have guardianship. They don't own the land. But is there a need for land to be set aside where those that cannot acquire land in a market-related way can have the opportunity to go and settle in particular areas until such time that, you know, title deed is offered in those areas?
Yeah, the land which is owned by Makosi is problematic because actually I don't think they own the land per se, but they hold the land on behalf of people. The land is not theirs, as far as I understand. Indeed. It is not theirs, but they hold it in trust on behalf of the people of South Africa.
Yeah, just as a follow-up, whether it's Amakosi, sorry, Chief Justice, whether it's Amakosi or whoever holding the land, But is there a need for land to be held in trust, parcels of land to be held in trust for some communities or some people until they can get title deeds to be able to reside and have a place on that land? That's my question.
I don't think there is a need for that, because if it is your land, it is your land. But the problem will be with regard to subdivision as to how it is going to be subdivided to such an extent that you can be able to get a title deed. But it is not a problem, because it is your land. You must be able to get a title deed in respect of your land. So the problem will be with the subdivision as to how do you go about to subdivide that land if the Amakhosi are still clinging on it, on the premise that it is their land, or that sort of the thing.
Thank you, Chief Justice. I won't take it further. Thank you, Mr. Ncube.
Thank you very
Thank you,
much.
Honorable Singh. Honorable Kaba.
Thanks, CJ. Good morning, Mr. Ncube.
Good morning, sir.
Thank you very much. One of my questions has been covered. Now, the second one relates to the Act, this Labor Reform, Labor Tenants Act of 1996. It's 2021 now, 25 years later. I have had to intervene in matters where a farmer or farmers refuse labor tenants from converting their mud structures, mud houses into solid structures. And in some cases, refusing municipalities from extending services such as water and sanitation onto the farm. What has been the take of the courts? I'm raising this point, moving from your decision of judicial intervention to assist the poor and the lenders. Has there been any cases that have been brought before the court and to address situations such as this? Thank you so much.
The story of farm dwellers is very painful, there has been no case as such which has been brought to court where the farmer is refusing the municipality to provide services for the people who are residing on the farmer's land. But there have been cases where the farmers do not allow the labor tenants themselves to build brick houses. They want them to build the mud houses. And when he converts his mud house into a brick house, then it is a big story. And then the farmer will go there and demolish. I've just handled the matter at Harry Smith. Although the occupier had the right to occupy the land, but there came a stage when the house was dilapidated and he had to re-establish the house, to rebuild the house. In rebuilding the house, he had to use cement bricks, and it was a problem for the farmer, and the farmer just demolished it. Well, unfortunately, they were able to go to the Department of Land Affairs, and they got an advocate who took the matter to court, who took that farmer to court, and I ordered the farmer to rebuild the house which he had demolished. And I think it has been rebuilt now because there's been no application for leave to appeal or anything like that. I think, in fact, he did rebuild it. But in cases where the farmer is refusing the municipality to provide services, no, we have not had such a matter.
Thanks, Chief Justice. Thanks, Magistrate.
Thank you.
Thank you, sir. Commissioner Barnard.
Thank you, Chief Justice. Good morning, Mr. Ncube.
Good morning, sir.
In the Molase judgment, you make reference to the use of the inquisitorial proceedings as opposed to the adversarial process mostly used in South African courts. Could you explain to the Commission how the proceedings in the land claims courts are conducted, and you know, and when and how the inquisitorial proceedings are best used or introduced?
In the land claims court, we refer to inquisitorial proceedings in the manner that we start by holding pre-trial conferences. In the pre-trial conference, the judge is actually involved in trying to resolve the matter peacefully to the satisfaction of all the parties. But of course, you do not get involved to such an extent that you get your vision muddied by the dust of the fighting bulls. But you get involved to a certain extent, not to the extent that you become partial. It should not be seen to be taking up the case for one of the parties. But you try by all means. The first thing which I ask the parties when they come to me, I ask them, have you attempted settlement? And most of the time you find that they have not attempted settlement. They will tell you, no, we have not attempted settlement. And I tell them, I think it is better for you to attempt settlement first. And if you can't settle, then come back to me. And in most cases, once they go out of my chambers and trying to settle, they will sit down, they will talk among themselves. And when they come back to me, the matter is settled.
Thank you. Now, except for the pre-trial proceedings, are there any other instances, or when would you think best in the land claims would the inquisitorial work also? In other words, I take the point that it's in the pre-process, but once the trial starts, what instances would be good to refer or to make more use of inquisitorial process?
You can also advise them to go for mediation, of course. You can advise them to go for mediation or arbitration. But with regard to arbitration, then I don't think you are in a position to force them. You cannot force them unless they come to an agreement or sort of an agreement, unless that clause that the dispute will be referred to arbitration is made part of a contract. If it is part of a contract, then you can enforce that clause which is in the contract. But if it is not in the contract, you cannot force them to submit to mediation or arbitration. And once the case is in court, once you are presiding in that case, then there is no way of you being seen to be taking the case for one of the parties. Then once you're in court, you must remain impartial.
Now, in the context of this special master, and that's my last question in this regard, is you say that you refer to the appointment of the special master, and in referring to this inquisitorial and the processes, you say this will be in line with the appointment of the special master to assist the court. What was your thinking in that regard as to how the special master should conduct processes?
Well, the special master is able to go deep into the matter. The special master is able to go to the department. As I'm sitting there at the land claims court, I have no way of leaving the court and go to the department and try to look for the files which are missing, because some of the files there, we are told that the files are missing, and the department can no longer find those applications which were made by the labor tenant. So the person who can only actually and physically go to the office of the minister or the office of the DG in the department is the special master, who will sit down with the DG or will sit down with the minister and discuss the matter and see to it that the officials look for the files, and if the files cannot be found, they will have to get duplicate files in place.
Thank you very much. Thank you, Chief Justice.
Thank you very much, sir. Honorable Dodovu.
Thank you very much, Chief Justice. Good morning, Magistrate Ncube.
Good morning, sir.
I move from the issues of land to environment, your area of specialization.
Yes.
In your view, in relation to sustainable development, how important it is to protect and preserve the environment and enforce the laws pertaining to environment in order to bequeath the future generation a good life.
It is very important. We call it the principle of sustainable development, which says that if you are dealing with the environment, you must deal with the environment in such a way that you do not jeopardize the ability of the future generations to deal with the same product which you are dealing with. In other words, you must not deplete the product. And in actual fact, the NEMA, National Management Act, the National Environmental Management, also makes a mention of that principle. And also the Constitution, we must take into account the fact that the Constitution, Section 24 of the Constitution, guarantees every citizen the right to an environment which is not harmful to their health and well-being. It is very important.
Yes, those who do business, especially in the sea, they take all the species, and the future generations are really running the risk of seeing these living organisms in person. In the mining sector, those who explore mining, they leave communities under very strenuous environmental difficulties. In your view, the current dispensation in relation to those, do you think that the laws to enforce the current situation, are they adequate? Are there limitations and shortcomings that needs to be attended to?
In my view, the laws are adequate. It is only the enforcement in the sense that people do not report these atrocities. These atrocities should be reported so that the police can come on board and arrest the people. That is an offense. In respect of the sea, the Marine Living Resources Act does not allow it. And in fact, in the case of mining, the precautionary principle, which is one of the international environmental principles, precautionary principle, says that if we are dealing with the land, for instance, if we are dealing with the mining, after you have done what we are doing with the mines, you must rehabilitate the earth. You must rehabilitate the soil. If you do not do that, we are committing an offense. And it is an offense which must be reported to the police, and the matter must be taken to court to be dealt with in court.
Just last one, Chief, I'm from a mining area and I see this happening quite often. Mining companies, when they leave, they leave communities in desperation situations. Don't you think that in the course of doing this, we need public education to educate our people about this so that their rights are protected and they know their rights, and as I'm saying, they continue to be protected well beyond the mining activities, for example? Don't you think that?
Yes, it is important that people must be educated along those lines. But also, if people are not educated, those who are educated who know that that is not allowed, they must take an initiative. They must take an initiative and take the matter up to the court so that the people can be dealt with according to law.
Right, thank you very much. Thank you, CJ.
Thank you.
Thank you, Honorable Dodovu. Professor Schlemmer.
Thank you, CJ. Good morning, sir.
Good morning. Good morning.
I would just like to know from you, you've been acting in the Land Claims Court and other courts for quite some time, specifically for a fairly long time in the Land Claims Court. Why haven't you applied prior to this application, which is a secondment, which basically assumes that you are a judge and you're just an acting judge? Why haven't you applied before, or have you, and were not successful? Could you please clarify that for me?
there's been a problem in the Land Claims Court, as I have said, that there were no permanent judges, so there were no permanent posts which were being advertised. They were advertised at some stage, but they were withdrawn. I applied at that time when the posts were advertised, but they were withdrawn. And the Land Claims Court has been working with the acting judges only, so there was no way in which I could get a permanent post there because there were no posts which were advertised.
But this then means if you were to be appointed now and you were to be moved back to KwaZulu-Natal, that would not sit nicely with you. Am I correct?
That I did not get that, ma'am.
This is a secondment.
Yes.
So if you were to be appointed now to the Land Claims Court, that secondment can at some stage potentially be withdrawn because that is what a secondment normally is. So that may mean that you will have to go back to KwaZulu-Natal. And it seems like you are not very keen on having a position at a normal bench, but just at the Land Claims Court.
No.
Is it not?
No. If I'm appointed, I'll be appointed in a permanent position. And the post is in KwaZulu-Natal. That permanent post is in KwaZulu-Natal, but I'll be seconded to the Land Claims Court on permanent basis, not as an acting judge.
Thank you, that clarifies it.
And in fact, that is how I'm working at the moment. I'm based in KwaZulu-Natal, and I work in both High Court KwaZulu-Natal and the Land Claims Court.
Yes, but as an acting judge.
Yes.
Thank you.
Advocate Mpofu.
Thank you, CJ. Good morning.
Good morning, sir.
Yeah, well, you've covered almost everything I wanted to ask you, and I agree with you. You've resolved some debates I've been having with the minister. Thank you.
Thank you.
On a lighter note, like Prof, I would be saying, why don't you apply not to the Land Claims Court, but to the Constitutional Court? Thank you. The first issue is an issue that you have explained. Do you think that, well, I think you have answered this question in fairness. So maybe I'll just put it as a comment to say that I don't believe that any lawyer who is honest can ever read Section 25 to say it allows for expropriation of land without compensation, because it says so in English.
Yeah.
You don't even have to be a lawyer. It says you can only expropriate subject to compensation,
Yes.
the amount of which and the time and manner of payment of which are either have been agreed to, and so on and so on.
Yes.
And then subsection 3 says the amount of the compensation and the time and manner must be just and equitable.
That's correct.
So
Yeah.
the 6 or 8 words there that make it clear that there must be a
Yeah,
compensation.
there must be compensation.
Now, the issue that I wanted to ask you is, do you agree that land reform, I don't like that term, but let's use it for now, that land reform cannot be driven by the courts? If we are serious about repossession of land, which was taken by violence over so many years, the courts cannot be the mechanism. The courts are there to dispense justice.
Yeah, that is correct.
Not to just dispense land.
Yes.
It's as absurd as saying that you could deliver housing by going to court. Every time you want a house, you must go to court. And it would take a million years for people to have houses.
Yeah, that is correct. Yes, I agree. I agree.
Okay, thanks. And the danger, the reason I'm raising this is because for 25 years, it was believed that the market can deliver land. And people realized that that's just a nonsensical notion.
Yeah.
So we don't want another 25 years thinking the courts can deliver land, because that is not going to happen. Now, the other issue, the last question I want to ask you is private ownership of land. And I'm glad you are an environmentalist, because I think you'll understand this question. Do you agree that the notion of private ownership of land is actually a silly notion, because the land is finite and it belongs to all of us. And we're only here, the average lifespan of a human being is not more than 90 years, let's say 100 years. And the land will be here for millions and millions of years. That the land, like the air, the issues you're talking about, pollution and so on, actually belongs to all of us, and we must just find a way of sharing it, and keeping it for generations to come.
Yes, really.
You agree?
I agree. That is true.
Thank you very much.
That is true.
Honorable Moimo.
Thank you, Chief Justice. Good morning, Mr. Ncube.
Good morning, sir.
Mine is on the point that you raised earlier on around the Ngonyama Trust, which I want to draw parallel with the Communal Land Rights Act, popularly known as CLARA, that was declared unconstitutional. One of the issues raised there is that it promotes duality of the property regime, one for the urban contingents and then one for the rural contingents. Two, it perpetuates the land regime according to the old Bantu Authorities Act. And three, that it perpetuates a lack of security of tenure. From your understanding, what is it that urgently could be done by government to ensure that there is a security of tenure for people that are finding themselves under the leadership of traditional councils, because there is nothing that they can do with the place that they are occupying. They can't go to the bank and say, here's my security, I want to embark on a business. Can you hold this as a security for my ventures? Thank you, Chief Justice. Thank you, Secretary.
I think it will make no harm. I think it will make no harm if the government can expropriate the land in order to give it to the people. Because people need land, people are landless, and that land which is being referred to as communal land does not help the people. So it will be for the government to expropriate the land and give it to the people and put in place the mechanism of getting title deed for the people so that they will have title deed to that piece of land. That is the only solution, the way I look at it.
So how are you gonna deal with the challenge posed by traditional leadership? Because they have been very vocal, and in one of the point raised is that because of their interest, it delays the right of communal people to also enjoy the benefits of democracy.
Well, all people are vocal when it comes to land. Even private landowners are vocal. They also have got their own issues about their own land. So if the traditional leaders are also vocal, it will not be something new. All people are vocal when it comes to their land, but still the land can be expropriated if we are serious about giving land to the landless people.
Thank you, Mr. Ncube. Thank you, Chief Justice.
Thank you.
Thank you, sir. JP Mlambo.
Thank you very much, Chief Justice. I heard Honorable Singh refer to you as Kambule.
Yes.
Oh, so Mzilangata is the ones we start with an M.
Yes.
I see. That's a very nuanced difference, but thank you very much. I see you mentioned a apartheid matter when you were completing the questionnaire in the High Court. Has that parted matter been finalized?
The parted matter, actually, it is being finalized. All the evidence is before the court now. It was a very long matter, but all the evidence is before the court. The advocates will be now sharing the exchanging their heads of argument. Next month they will be arguing the merits, but the matter is almost finalized.
How long has it been parted? Since, well, from the time before you completed the questionnaire and told us about it.
From the time before I completed the questionnaire, it was already parted, but actual fact, this is a claim for damages. It started with another judge who decided the question of liability. Then it came to me on quantum only. So quantum usually it takes long. Those experts who are giving evidence there, it takes long. I had 8 experts who were giving evidence on damages. And yeah, it started before I completed the question.
But it's a High Court matter, and High Courts run on a running roll basis. So that's why I'm asking, why has it stayed so long parted and not been finalized?
It is no, on my part, it has not been there for a long time, actually. Because the moment I came, the JP gave me the file, and I started with the trial almost immediately. I started with the trial, and as I have said, it was a long trial. Evidence of the plaintiff, evidence in chief, took 5 days to complete, and the cross-examination took 9 days. Cross-examination itself, the plaintiff alone, it took 9 days before he could call the other 7 witnesses who came after him.
Okay, so you say on your side it's not been long, even though you completed your questionnaire in 2019. We're sitting in 2021.
No, I mentioned it in the questionnaire because it was a parted, but not because it was a long outstanding parted. Okay. So I thought it was fair for me to say there is a parted, which is still outstanding, but not that it was a long outstanding one.
Yeah, the only reason I ask is it is of interest to us as heads of courts to make sure that matters run and are finalized.
Yes, I agree.
You agree?
I understand.
Yeah. Other than the special master case, do you have any other cases that have, your cases that have gone either to the SCA or to the Constitutional Court, and with what result?
I had about 3 cases from the Land Claims Court, which went to the SCA, and my orders were all upheld. And I had 2 from the High Court, which went on appeal to the full bench there, and my orders were also upheld. And one of them is reported.
Yes. Thank you very much, Chief Justice.
Just as a follow-up, Chief Justice.
Thank you very much, Judge President.
Just as a follow-up, Chief Justice Madonsela.
Yes, sir. Please go ahead.
I heard that Judge President Mlambo referred to the running roll. Just for the record, in Durban, KZN, we do not have a running roll in the sense of a running trial roll, in the sense that they have in Joburg, where when you are allocated a matter, you have to run through it and still finalize it. Is that correct?
Yes, I agree. No, in Durban, there's no such.
Thank you.
The President.
Thank you, CJ. Good morning, Mr. Ncube.
Good morning, ma'am.
You've already answered my questions. I just want to point out that although the SCA overruled you in Welase, there was a minority judgment written by a certain woman judge that fully supported your reasoning and order.
Oh, yes, yes, I agree. That is true.
Yeah. Thank you, CJ.
Thank you.
Thank you, President. Mr. Ncube, your excuse, sir.
Thank you very much, Sergeant.
Thank you, sir.